Okay, let's go ahead and get started. Thank you so much for joining us today for our Introduction to Trust and Estate Mediation webinar. I'm Stacy Groh. I'm the Director of Marketing and Client Experience here at the law offices of Daniel A. Hunt. We're really excited to be hosting another webinar today. If you've missed any of our previous webinars, recordings are available on our YouTube channel. And on that same topic, we are recording this session today as well, so it can be available on that YouTube channel for you to rewatch later or share, or for others to watch and learn from. To find our channel, you can search Law Offices of Daniel Hunt on YouTube. We currently have close to 50 educational videos on there. If you're interested in checking out more content, it's available for free. Also, by tomorrow, I'm going to be sending all of our webinar attendees a PDF of our slides from today's webinar, as well as a link to the recording once it's ready. So today we have an information-rich presentation for you with two mediation experts, both of whom are based in the Sacramento area, but serve clients throughout California. A few housekeeping items as we begin. First, some Zoom mechanics. If you're on a computer, if you move your mouse down to the bottom of the screen, you can view your controls down there. On the bottom left will be audio settings. You also see a chat box. Feel free to communicate with us, the hosts, throughout the presentation using that chat box. There's also a Q&A box where you can type any questions you might have as we proceed. And we anticipate that our webinar should last around an hour today, with a few minutes at the end for a Q&A session. So if you have a question that is general, feel free to type it into the Q&A box at any time. If you have a question that is very specific to your personal circumstances, we're going to be sharing contact information at the end, so you can reach out to our two speakers today for more personalized advice. So with that, I'm going to go ahead and introduce our speakers. So speaker number one is Daniel I. Spector. He is a mediator and arbitrator at Judicate West. Dan has 30 years of practice. He's handled over 400 mediations, and of those, he settled 397. So that's a very impressive track record. We also have Daniel A. Hunt. He is an estate litigator and a certified specialist in estate planning, trust, and probate law. Dan Hunt has over a decade of mediation experience. He also has a 100% mediation success rate, meaning that a settlement was reached in all of his mediations. So again, two wonderful speakers, really excited to hear what they have to share. So I will turn the time over to them.
Well, thank you very much, Stacy, for that introduction, and I'm so pleased to have folks join us. If we can go to the next screen, we're going to be talking about mediation compared to other methods. There we go. Okay, so we're talking about mediation in trust and estate disputes, which is another way of saying the fights over the assets, usually after people die and sometimes before. And as some of you may know, these are really difficult disputes. They're different than, say, a dispute between a bank and its customer, or even people who have rear-ended each other. In this case, we have family members fighting amongst each other. There's decades of history and story that complicates and frankly populates the dispute. And so for that reason, you'll learn today why mediation is such a good fit as a way to solve these issues. When we talk about mediation, mediation is just one way in which to end a lawsuit. And I like to compare it and teach about it in part by contrasting it with trial. So at trial, if you have a trust and estate dispute, you pay your lawyer lots of money to prepare for a very long time to gather the evidence that he or she is going to ultimately present to a public official, namely a judge, in a public facility, namely a courthouse, and ultimately that person who doesn't know you, doesn't know your family, doesn't know your sibling or your step-parent, will make a ruling. That person has an agenda. The agenda is to get you and the litigants in your case in and out of the courtroom as quickly as possible, because there's so many other people waiting to have their matter decided. Ultimately, during the trial, your role is very limited. Your role will be to sit there like a potted plant, listen to your lawyer work his magic, as Dan Hunt famously does, and ultimately you will testify, but your testimony, the time you'll testify will be relatively limited in the grander scheme of the case. Eventually, the judge will make a decision, and that decision will be limited to what the law allows. That is, the outcome is confined to the parameters, to the shape and ends that the law describes, and nothing more, nothing less. Eventually, there's a judgment that's rendered, a decision that's rendered, and one party may appeal. So when we talk about mediation, we need to contrast that to trial, because in mediation, you're in control. That is, the parties are in control. They're the ones who decide whether or not the case gets settled, and they decide whether the shape of the outcome. And we can use anything we want. We can decide however we want to end this case. We can decide it so long as it's consistent with the general policies of the law. In that case, or in mediation, there is a person who's in charge of the process. That would be the mediator. And the mediator's role is not to decide anything, but to facilitate a resolution. That is, to help the litigants, the parties, and their lawyers understand the other's positions, and then ultimately help them craft a resolution whereby they each get what they need. Again, very different from trial, where someone is simply handing down to you a decision. In mediation, you're in control. In arbitration, which is used sometimes in trust estate cases, it's the process is very similar to trial. That is, rather than you hire a person, usually a retired judge or a very experienced lawyer with deep experience or deep understanding of the law, and that person will decide who gets what under the law after the lawyers take their turns presenting their evidence and arguing the points of law. Again, your role in arbitration is similar to trial. You'll testify, but ultimately you'll simply be writing your lawyer checks and watching them do their thing. You will have no control over the outcome, the shape of the outcome, etc. Mandatory settlement conference is something that's a function of the judicial process. That is, usually when we go to trial, prior to going to trial, the court will have either a judge who has agreed to serve a few hours to try to get the parties to settle their case, or sometimes they will pick from a panel of lawyers in the community who have volunteered their time, a limited amount of time, in order to try to engage in a negotiation or facilitate a negotiation between the parties. My experience with mandatory settlement conferences and these types of cases is that they're not the best tool to get cases resolved because of the time constraints. That is, these cases, by their nature, take time to allow people to understand and appreciate the other side's positions. We're going to talk more about that later, but it's just something that can't be crammed into a 2 or 3 hour process. So when we talk about the best methods of resolving these types of cases, the trust and estate disputes, overwhelmingly, the best process, the best fit to end these cases is mediation.
Dan, can you talk about maybe real quick why mediation is more popular than arbitration in trust estate litigation?
Happy to.
I have a thought as well on it.
Yeah. So There's a couple of very important distinguishing factors between mediation and arbitration. Arbitration, because arbitration is a decision-based process where someone unrelated to the parties is making a decision. The lawyers and their parties have an interest in making sure that all of the information is given to the arbitrator in advance of that decision. In addition, usually arbitration, unlike trial, has no right to appeal. As a result, everyone in the industry, the lawyers themselves, to best represent their clients, have to spend as much effort as need be to make sure that everything is presented to the arbitrator before that arbitrator makes the decision. Because once the arbitrator makes the decision, that's it. There is no right to appeal. And so you have a longer run up to arbitration than you do mediation, because everyone feels like they have to get ready. And then the arbitration itself can last weeks, if not months, taking time to make sure that all of the evidence is presented to the arbitrator. And then ultimately the arbitrator has no time constraint by which a decision has to be made. In contrast, in mediation, we are done usually in one day. That is, in one day, we can identify what the needs of the parties are, negotiate a resolution that fits each of their needs, memorialize that agreement in a written document that everyone signs, so that in effect the case is over in a single day.
So my war story here was a great learning lesson was that when I had gone to arbitration once early in my career, and it was exactly that. It was almost arbitrary. We were in that dispute trying to figure out who a house belonged to, because mom had done a handwritten note at the kitchen table. It was obviously vague, ambiguous, the terms that were used there, and we were there trying to get a decision as to who is going to own this house at the end of this. Now that mom was dead, and we had this handwritten note that essentially kind of amended what her plan was. And we went prepared, obviously, gave the case to the arbitrator, prepared and presented our case to the arbitrator. And then the arbitrator made what I call arbitrary decision to not only decide who got the house, but also, we didn't even present evidence on this, but also he decided who was going to be the trustee at that point, which my client ended up getting removed as trustee. And now, as Dan obviously knows, but the rest of you don't know, the attorney-client privilege transfers with the office of trustee. So now all of our emails that we had sent to the trustee, calling this opposing counsel dirty, rotten scoundrels, things like that, can't believe what they're doing, now had to be turned over to another trustee. So it was something that I found very disconcerting, that when you go to arbitration, people don't do non-binding arbitration generally, because they're like, well, what's the point of it? They're going to go for binding arbitration. And then in that sense, also the frustration on the litigator side of it is that really the rules of evidence are very, very, they play fast and loose with those. If I go to court, I go to a trial, at least I know the rules of the game that I'm playing. Whereas in arbitration, the arbitrator can just make a decision based off of some hearsay that was presented. Whereas at least with rules that we have that protect us in trial courts, so that's why I tell my clients, we can go to mediation, we love it, or we can go to trial. But arbitration, I'm not going to do it because it's too high risk, and there is no option to appeal that generally. And then on top of that, I don't know how this arbitrator is going to come to their decision. Could be something that's kind of out of our control. So I don't like that. But anyway, great thoughts on that. So next, how to prepare for mediation. That's going to be the focus here, because that's obviously, I think you can see from Dan and myself, that mediation is much preferable over arbitration, and almost also the mandatory settlement conference, as I mentioned, I think in some things that I've written, the time constraints as well. Dan pointed that out. Like, you have a judge who's super, super busy, and they're not going to take all day to sit there and try and get your case resolved. And also, they're not going to, I think, push as hard or take positions, because they're not supposed to do that in that sense. They're just there to try and say, hey, do you have an offer? You want to settle? Great. No, if not, let's go to trial. That's kind of how those mandatory settlement conferences work. So mediation, focusing on that. First thing, selecting a mediator. When it comes to selecting a mediator, you should just pick Daniel Spector, right? That's the long and short of it. No, but we'll use him as an example as to why selecting a mediator is super, super important, because you want to choose someone, obviously, that has background, extensive background in trust and estate litigation. That should be abundantly clear, because you're paying this mediator not to take a side. And sometimes that's something that the clients get confused about, is saying, okay, we want the mediator to be on our side. Well, not necessarily, because if the mediator just takes your side because they like you or whatever, and then you get all puffed up and feeling like we've got a great case, when in actuality you don't, and then you aren't able to reach a settlement at mediation, and now you go run off to have yourself a trial because you think your case is great, grand, and wonderful based on some faulty information that a bad mediator gave you because they misunderstood the law. Now you're going to be out the money of mediation. Now you're going to be out the money of trial preparation, and you're going to lose. You're paying a good mediator who has that background of experience, so that they can look at the case, they can look at the facts, they can apply the law that they already know, and then kind of help each side see the strengths and weaknesses of their case. So selecting a mediator, when it comes to that, you have to pick somebody that has, I would say, decades of experience in trust and estate litigation. And that's the only type that we use. Also having a good temperament. And we're going to talk about this, I guess, a little bit later, actually, so I'll save that. But first off, selecting a mediator, how that actually functions. Typically, if both sides are represented, the attorneys can agree on a mediator mutually and say, okay, let's go use this mediator. Sometimes if they can't agree on just one attorney will say, here, I'll give you three options, and then you select one of those three that I submitted. Kind of like drawing straws, which one person gets to actually pick up the straws to draw, and then the other one has the final say. So that's the first thing, is selecting a mediator. Secondly, providing a mediation brief. So a mediation brief is how you convey all of your information, your case, to the mediator. So these can be very, very extensive. These can be something that you're going to have lots of exhibits attached, possibly deeds, possibly appraisals, statements showing where money was transferred to and from, so that the mediator has all of the facts before them. So it can be a very, very expensive document to put together, but also very, very important, because never would you want to have a mediator that only has half picture, making not a decision, because they don't make decisions, but essentially they've got to understand the case so that they can go and consult with the other side or your side, saying, here's your strengths, here's your weaknesses. So that mediation brief is something that the attorneys, if you're represented, they always put that together. And good attorneys will, of course, have their clients review those and make sure that the client is comfortable that all of the positions, their strengths, and even their weaknesses are put in there. Third parties exchanging any information required for a successful mediation. So it's optional whether each side exchanges mediation briefs. I think most mediators, they prefer, and Dan can chime in on this, most mediators probably prefer that the parties exchange their mediation briefs. Do you want to talk about why you prefer that, Dan?
Sure. And you're absolutely correct. It is my preference. And it's because the nature of a successful mediation is enriching the understanding of each side to the other side's positions. And we have to do that in order to make the negotiations effective. If we just have the parties show up and start to negotiate without any understanding or appreciation of their positions, the negotiations will fail. And so the exchange of briefs allows the parties and their counsel to understand in advance of the mediation where the other side's coming from. They're not going to agree with the position, but they need to understand it. And usually reading the brief is the first step in that understanding. It doesn't complete the understanding. That's that's part of the role that I play is facilitating that. But it helps because, as we talked about earlier, so much of the benefit of mediation is that it occurs usually in one day, and time within that one day is a precious resource. So the more we can accomplish in advance of the mediation to establish a mutual understanding of each other's position, not an agreement, but understanding of each other's position, the better off it is for everyone. And so there's few tacks to take that are better than exchanging briefs before the mediation.
Right. So the mediation brief will lay out the position, obviously. And in this area of law, we live in the gray area. The black and white, it's something where it's like we can all agree that, and you can attach as an exhibit, the money in the account that was shown transferring from, account that son was POD and transferring over to daughter was POD. That's black and white. We can see that. But the parties will absolutely disagree on whether son was unduly influencing mom to transfer that money over to daughter. There's nothing in a mediation brief that would convince the other side of that undue influence. But as for the black and white stuff, sure, you can attach that, and it's important that each side knows what the other side knows, because also something that clients sometimes think is that they watch too much TV and they think that at trial there's these kind of smoking gun evidence things that come out, like, oh, if we can just we'll pull that out at trial and then dun, 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 we win. In actuality, if you try and pull that stunt, what happens, Dan?
Well, what happens is that someone else has an alternate position, and the judge is left scratching his or her head, and you will not get the result that you think you're going to get.
And also, a judge can exclude it from evidence completely if you didn't disclose that. When you said, okay, hey, you put out some discovery requests, and then you didn't give that over, the judge can say, I'm not even going to allow that in, because you're not giving the other side an opportunity to vet that evidence, to test it for whether it's authentic, those kinds of things. So it can completely be withheld if you're doing it that way. So that's why we try and avoid all of that mediation. We put everything out there so that each side knows what the other side is coming to the table with. That's the helpful part of exchanging information. Another example of that is if you have a lot of times we're fighting over property, and if you have an appraisal on a piece of property, give that to the other side so they know, like, this is what I think the property is worth. Stuff like that. Statements on how much is in the account, how much is in the trust. Give that to the other side so that we can be making decisions based upon accurate information. All right, next one, attorney and client meet to discuss the mediation process. That's obviously very important so that as an attorney, if you just show up to mediation not having met prior with your client, and you are sitting there with this bewildered client as to not even knowing what is going on, I mean, you can imagine taking a patient in for surgery and having given them no explanation as to what's going to happen in the process. They're going to be given masks, laughing gas, whatever. It can be very disconcerting to a patient to go through that process. And so it's very important that the attorney and the client meet together prior to mediation to go through this, because all of you who are listening right now, you are miles ahead of many people that go to mediation, where they just show up with the client and now they're expected to make this decision that will affect the rest of their life, affect inheritances, affect relationships with family, not knowing what's going to happen. So it's important to meet together, discuss the process, essentially going through everything that we're going through today. And then lastly is to head off to mediation. And even doing that, it's important to note, nowadays many mediations happen over Zoom. So sometimes clients are asking, how does this process work? And you can do it Zoom, you can do it in person, lots of different ways that you do that. So
can I add, you've raised a variety of really important issues. I'd just like to kind of augment just a few of them, if you don't mind, on this slide.
Of course.
I think well, first off, you hit on something in terms of the nature of these disputes at trial that I can't underscore enough. In these cases, unlike personal injury cases or disputes over between financial institutions, the star witness is gone. They're dead, and they can't testify. And as a result, it creates a vacuum of evidence. And into that vacuum, the lawyers then at trial are presenting people who were around the circumstances that were the subject of the lawsuit, but everyone has their own perspective as to what happened. So when we then, once the lawsuit's filed, and we now find ourselves in a mediation, it's important to understand those perspectives. We, again, are not going to agree with the other side's perspective, but you would be amazed how different two people or three people or four people view the same thing at the same time radically differently. It's a study in kind of how humans go about our perception, but we bring to our own experiences our own lenses, so to speak, and we see things through those lenses with judgment and morality and experiences that other folks don't have, and so they interpret the same activities, the same actions or non-actions with complete different conclusions, reach different conclusions than other folks do. And so part of the mediation process, again, is to really focus on the difference in perspectives, and at least to understand how it is that person has the perspective that they do. The mediation brief helps color that, helps explain that to me, the mediator, which then I can use to explain and teach to the other side. It's also critical, as you said, Dan, prior to the mediation, that the client and the attorney meet to talk about those things, to talk about not only their perspective, but also the other side's perspective, and the way the mediation is going to work, and the process that the client, or sorry, the attorney knows is going to be used. Because as you stated, mediation to someone who hasn't done it can be really bewildering and unusual. So that's all.
Excellent points. We can go to the next slide, Stacy.
Okay, I believe this is so. This is me. So how mediation, trust estate mediation works. So before you arrive, I've reviewed all of the materials, and the reason I do that, again, is not to decide anything, but rather to enrich my understanding of the different perspectives of the case and the applicable law, so that I can make sure that I can help the other sides understand not only the other side's position, but also their own. One of the benefits as Dan kind of referenced, of having a mediator in this particular type of dispute with deep understanding of the law and experience trying cases, is that I can explain to both sides that I've handled both sides of these cases multiple times. I know how this is going to roll out, and I can help them understand, at least with the benefit of my experience, confirm for them where their strengths are, help them understand where their weaknesses are, and ultimately enrich their understanding of the other side's position as well as their own. The way once I review the briefs, and everyone comes together either virtually on Zoom or now or in the past together in one building, I will I'll introduce myself to each side, that is counsel and the parties. I will then talk to them about my process, the nature of mediation, the confidential provision that, as a matter of law, everything that is said in mediation stays in mediation. It's encapsulated mediation. It can't be used later in the unlikely event that we don't settle the case and go to arbitration or trial. And so then I will begin to shuttle between rooms, because the parties are separated with their lawyers in separate rooms, either virtually or in physical different rooms, and begin to discuss with them their positions. My own process is I start by listening. That is, I want to give the opportunity to the parties to tell me their perspective. I think it's important in these types of cases to allow the parties to get their stories out. if they've already gone through depositions, they've kind of done that already. But oftentimes I get these cases where they haven't, which is good. It's good for everybody if we can get these cases into mediation as soon as possible. And so it's often that I'm dealing with parties who haven't had their depositions taken, haven't had the opportunity to kind of tell their stories. So I give them that opportunity. At the same time, I'm listening for information that I think would be impactful to the other room. And once I hear that, I recite back to the party and their lawyer what I heard to make sure that I have it right, and ask them permission if I may share it with the other room because I think it would be impactful. This goes on. We usually start these mediations in the morning around 9:30, and that process usually takes somewhere between 2 and 3 hours, sometimes longer, sometimes less. And once I feel that the parties have an understanding of each other's positions, then I will ask the parties to begin to their negotiations. Now, the last thing I do before we engage in negotiations is I'm asking the parties to tell me what's important to them. What do they need out of this process? I have to understand what it is they need. Yes, sometimes it's just money, then that's fine. But usually in these cases, everything, whether it's money or mom's collection of whatever she had, or the china set, or dad's gun collection of the tools, or whatever, it all has meaning. These assets have meaning, and while they may not have great objective value, they have incredible subjective value. And so I spend a little bit of time with people, or a lot of time, finding out what it is they need, so that I can then help them formulate a negotiation, a process whereby they get what they need. It's like the Rolling Stones song in these cases. You don't always get what you want, but with me, at least with my mediations, you get what you need. Eventually, we will go back and forth and work through a settlement and the terms. Again, one of the things that I bring to the table is, because of my experience with this area of law, I know all kinds of ways that I can work with the lawyers to try to craft a resolution using either the probate process, the trust process, potential tax savings, et cetera, as well as financial products that get people closer to what it is that they need. And all of that, again, is at our disposal. Whereas at trial, it's not. At arbitration, it's not. But at mediation, all of those tools are at our disposal, and we work together collaboratively to try to craft a resolution that works not just for you, but also for the other side. Ultimately, we memorialize that agreement in a settlement agreement, in a document. The document is circulated amongst the lawyers and their clients that day, and edited and then signed. And with that, effectively the case is over. Usually in these cases, it has to be approved by the court, but that is a pro forma process that the court's not going to get in the way of if all the parties have agreed to resolve their dispute. Dan, anything to add to that?
I don't think so. I think that was very well explained. Yeah. So no, I think we're good. We're good there. We can go on to the next slide. So optimal mediation results, how will we get those? We've already touched on it a bit. We're exchanging as much information prior to mediation as possible. I think that many times I get decision fatigue. I don't know if Dan's like me, but I get decision fatigue because every day I'm asked to make, I don't know, dozens and dozens of weighty decisions. And many times my response, if somebody's asking me to make a weighty decision, many times my response is I don't have enough information upon which to base a decision. And so that's where we've gotten hung up in mediation before, is that if we just, it was premature because the other side hasn't answered questions that we absolutely need answered prior to being able to come and say, okay, let's make this final decision here with a settlement agreement. And that's where I don't lord my success percentage over Dan too much, because he has way more experience, way more opportunities, but only missing 3 out of 400 is very impressive. But I did have the ones where we had to come back for a second round and finally got it decided. But after that first round, it's because we just did not, it was premature in that we didn't have enough information to make that final settlement agreement. So we said we had to call it. We said, no, we're not going to settle this today. We can come back. And we came back a month later after we got more bank account information, after we looked at more actions that the trustee had taken. And so I think that's why if you want it to be successful, not rushing into it, but finding the balance between getting enough information and not having enough to make that decision. Because I have had clients where they want to unturn every single stone that is possibly out there, and that just plain costs money. And so it's you got to decide to say, okay, at what point are we having diminishing returns on our discovery process here, and where it's like, okay, we've seen 98, 99% of what the trustee has done. So let's just go to mediation with that and try and get this matter settled. But exchanging as much as possible beforehand, that's what's going to make it so that you can actually be successful. Then also, and Dan may disagree on this kind of bullet point here, my thoughts on this, but I tell my clients, I said, go and understand there's no winners and losers in mediation, because the mediator is not going to say, you win and you lose. That's not what they're there for. The mediator does not make that decision. Essentially, what I tell my clients many times is getting both parties to be equally unhappy. And I hate saying it that way, but sometimes it's that way, where you feel like in mediation, you feel like you do have to give something up. Because otherwise, if you're not giving anything up, and this is another point that's not on there, that I tell people, if you're going in and just not, and your settlement position is essentially what you'd win at trial, then there is no point in being at mediation, because anybody could go off to trial and completely lose. And so if you're telling the opposing party, well, I'm only willing to give you $100,000, and that's what they would get losing at trial, then there's no point in doing this. They can just go run off to trial and get $100,000, even if they completely lose. But that's why I think it's having the parties understand, going in, knowing that they're going to have to make some sort of concession, that it's not going to feel like you just won a trial. That feeling is not going to happen at mediation. There's going to be some concession to get the parties to settle. Next one, knowing your range of reasonableness. That's something that I also, once again, in that meeting that we discussed, where the attorney and the client meet together prior to mediation, is going in and discussing what your range of reasonableness is, where your settlement range is. You should know your bottom, where it's like, okay, that's as far as I will go. Anything below that, and typically, once again, it's money-wise. Typically, we can talk about tangible personal property as well, that's included, but typically it's, here's my dollar amount that I won't go below. Anything beyond that, we're going to go roll the dice, take the risk of having ourselves a trial, typically, or continuing on with discovery, whatever it may be. And then your top end being like what the best possible settlement you could get. Knowing that range, I think, is important going in there, so that you can really save a whole lot of time and money. Because once you're doing it with the mediator there, you're paying your attorney, and you're also paying half of Dan's fee, which that's a more expensive way to try and figure out your range of reasonableness, as opposed to going into mediation knowing this is where I'll settle in this range, and being a little bit flexible with that would probably be good. Then being aware of the consequences of an unsuccessful mediation. So also important to tell my clients that if mediation doesn't work out, what happens from there? And that generally means we're going to continue conducting more discovery, and we're going to continue preparing for trial, and then eventually have a trial. And as Dan was saying earlier, where we're dealing with these family relations that go way back, you're dealing with multiple parties that see the same thing in such a different light. Understand that in trust and estate litigation, generally, you are not entitled to a jury trial. you are entitled to a bench trial. That means that one person, a judge, is going to be making the decision. And if multiple people who generally, I think people generally are pretty reasonable, generally, but if multiple people see the same act so differently, many times I feel like it's rolling the dice, because now that one judge is being asked to interpret and make a ruling on this act as to whether it was whether the person had capacity or not. Holy cow! I can't tell you how many times I've had medical doctors that one sees a person has capacity, and then the other expert medical doctor says that person doesn't have capacity. And now you're going to present that to a judge and say, okay, you make the decision. Did the settler have capacity or not when they drafted this document? And it honestly is a crapshoot. I never give people like 100% chance of success at trial. Never, ever, ever. Because I've had it where judges, I'm like, there's no way they can't rule any other way than this. And then that judge ruled a different way. Why? Because they're like, this is a gray area. And they sided with this shade of gray as opposed to that shade of gray. But it's very, very rare that you have these black and white decisions that judges have to make. They're going in there trying to decide, did this person have capacity? Was this person exercising undue influence? Well, those are things that it's like, geez, if there was a math formula that we could punch that in, we wouldn't be here. So being aware of those consequences means you understand that your chances of success at trial, and I always tell people the highest I ever give is 80%. That's the highest ever. And then on down to where it's like, okay, no, you have the burden of proof, so it's going to be less than 50%. And based on these facts, you're not having a good chance, so you're going to want to settle for this amount, because otherwise you're going to lose a trial. But the consequences of the unsuccessful mediation is typically more attorney's fees, more sleepless nights, and an expensive trial where you don't know the outcome. You can't be assured of the outcome. Any other thoughts on that, Dan?
Well, you've again raised a lot of really great points. The only thing I would augment with regard to the range of reasonableness is, as a mediator, I completely understand both the client and the counsel's proclivity to come into mediation before we step into mediation with kind of a bottom line, and sometimes that's appropriate. But what I try, if there's lawyers out there on this program or listening, I would suggest as a point of practice that that be flexible, because if I do my job right as mediator, I'm going to unearth for you some additional information that's going to be impactful during the mediation process that may impact your range of reasonableness, that may either adjust downward or upward your position. And so I think it's important that we, as important as talking about the process and talking about your goals and expectations between client and attorney before a mediation, it's also important to talk about listening and flexibility, and being able to make your best decision within the mediation itself.
Yeah, I agree. I've been in that position. It wasn't too long ago. I was in a mediation where at the mediation, our client had these voicemails saved on her phone, and she played them there for all of the counsel and the mediator. And we'll just say that the opposing side's range of reasonableness quickly changed upon having that information that came out in mediation, for sure. I think we're ready for the next slide, Stacy.
Okay, and I think, Dan, you were going to handle the first two, and I was going to take the third.
All right. So biggest mediation mistakes to avoid: selecting a poor mediator. And I touched on this before. If they're inexperienced, unskilled, or ill-tempered, I've dealt with mediators of all that would fit in all of those categories. It's frustrating when you go to a mediation and the mediator, I've forgotten more of the probate code since I woke up that morning than they ever learned. It's very, very frustrating to have to try and teach a mediator the probate code, as to saying, no, that's just plain not the law. Don't do that. Don't select a mediator that doesn't know the law. Unskilled, that would be somebody who hasn't done many mediations. Don't go with somebody like that because it's going to be a total mess if you do that. Ill-tempered, also dealt with that. I could not believe I was in a mediation down in Los Angeles, and because it was something that we agreed upon. I looked at his CV and it looked great. And then when I get down there, this mediator immediately, as Dan said, he says the first thing we do is listen. Well, this mediator, he as my client was telling her story as to what was, very meaningful to her. This was her mother had died, and it was something that she had a lot of emotion with, and she couldn't believe what was happening. This mediator started to curse under his breath things like, "Oh, S word this," and "Oh, F word that." Very ill-tempered, and he would cut my client off. And so at that point, my client completely started to just retract from the whole process because of this ill-tempered mediator. He had a lot of experience in trust estate litigation. He was skilled in that he had a bunch of mediations under his belt that he had conducted. But as for his temperament, my goodness, he was able to completely drive my client's willingness to participate in mediation right out of the room because he was just ill-tempered. It was just bad. He was not a good listener. He formed opinions way too quick. So that's a big mistake, is picking a bad mediator. My goodness, just pick somebody that's great, and it works out much, much better. Number two, being unprepared with the necessary information. Like I said, the time where mediation has broken down and hasn't been successful is where many times that is where either side doesn't have enough of that information. A lot of times it's a trustee who, like, for example, hasn't completed a full accounting. And the beneficiary is sitting there saying, how can I make this decision as to how much I'm going to walk away from this estate with if you haven't even accounted for everything to me? I've still got all these questions about what this money was spent on, and you haven't answered that. So being unprepared, going in there, not having, where it's like, or appraisals on a property, knowing how much a property is worth. Everybody can sit there and scheme all day as to how much this property may be worth. Well, let's go out and get a professional appraiser and then have that at the mediation so we can all agree this is the number. It might be 10,000, 20,000 this side or 10,000, 20,000 that side, but at least we have the information upon which to base the decision here. So going to mediation without as complete a picture as possible is another way for mediation to break down. And then Dan, third point.
So the third point to mistakes to avoid would be an unwillingness to see the other side's perspective. And it's such a difficult thing to do, that is to see someone else's perspective and to understand it in the context of a conflict. We don't want to do that. It's really, without getting too kind of psychological, it's against our nature. We hold on to our own beliefs, we hold them to be true, and we are disinclined to open ourselves to other person's positions about things that care deeply to us, particularly when we're in a defensive stance in a conflict. But in mediation, we must do that. As Dan kind of intimated, I think a couple of slides ago, the nature of mediation is settlement. Settlement, when we use the word settle in our ordinary lives, we're not talking about winning. We're talking about compromise. And to get to compromise in this conflict, in this process, it is necessary to at least try to understand, to listen for understanding what the other party's position is. Where my mediations in these cases get most difficult is when I have someone who just either can't or won't do that. And it obviously it slows the process down because we can't get to the next phase meaningfully to negotiate because they're unwilling to let in for consideration any other perspective than their own. I've settled 397 out of 400 cases, so they all eventually get there to some degree, but it's just a matter of how efficiently we do that and how painful it is for everybody in the process. The more readily we are to set aside our own beliefs and at least try to understand the position of somebody else, the more efficient and effective the process will be. I wanted to pick up one other thing that Dan on this slide identified. Again, in my own not so humble opinion, these cases I think are really, really complicated. They're amongst the most complicated types of legal disputes that we have in the law, just because they involve family dynamics on top of estate plans, which are complicated transactional documents, and then actual transactions involving various types of assets and their histories. It can get really complicated. And as a result, as a mediator, there's all kinds of opportunities to set the process back and step into a hole unknowingly because you don't have the experience or you're used to kind of telling people what to do. In my own legal practice, it's why I generally avoid using judges as my mediators for these cases, because judges have spent their careers deciding things, not listening, not facilitating, but deciding things. And in mediation, that's not what we're doing. What we're doing is we are facilitating, we are listening, and we are making deals. And so I think that Dan's first point regarding selecting a mediator is really critical, and finding somebody who has the experience and the temperament to handle it properly, to be a good listener, to be a creative thinker, and have the experience in this area is very critical.
All excellent points. It's something where it is complex because of that nature of our disputes. I tell people, it makes me laugh when I see people will say, all my life it's black and white. It's either right or wrong. There's these people who say that there's all this gray area. It makes me laugh, just because I think my whole day, I show up to the office and my entire day is pretty much lived in the gray area as to what is the right thing to do in this situation with this person who is incapacitated, what level of incapacity, all this kind of stuff. And people are going to see it completely differently. And so you need that experience to be able to be successful in mediation, both an attorney and a mediator who have spent their careers living in this stuff and can guide you to be successful. So Stacy's back for, I think we have a few minutes for some question and answer. And I don't know if we wanted to start. We did have some folks who emailed us some questions prior to our webinar. So we had the first question, I think, that Dan Spector was going to handle.
Okay, so I'm happy to take the first question we received yesterday was as follows. The question is, given the nature of mediation requiring a willingness to negotiate, what happens if the trustee or the trustee's counsel seeks to obstruct for unknown reasons? It's a really good question and a very legitimate fear. And it's easy to kind of speculate that perhaps someone is not interested in resolving the case because they're either generating a fee as a trustee or as trust counsel. If that's the case, again, based on my experience of the law in these cases, I can sniff that out really quickly. And I will remind the trustee and or her counsel that they owe a fiduciary duty, the highest duty in the law, to the beneficiaries, not to themselves. That by elongating the process, the administration, they are in fact self-dealing, which is a breach tantamount to fraud, and they may be held personally liable. So as a mediator, it's my job to sniff that out, flush it out, and get rid of it, and make sure that people come to the table in a constructive, good faith manner.
And then the second question, you have that. Do you have that in front of you as well, Dan?
I do. Second question is to you, Dan. What if the mediation negotiation is used as a tactic to collect billable hours from the estate rather than seeking a solution for the beneficiaries?
All right. Another wonderful question. So as for a tactic for whom, it would be my first question. Is it a tactic for the attorney to obtain more billable hours, or is it a tactic on behalf of the client to have this basically be a war of attrition where they just can't keep up with the amount of fees that are being required? So first of all, if it's a tactic for the attorney to get more billable hours, that's just really bad. If it's your attorney, my goodness, run the other way. Like any attorney that sits here and is just billing to get billable hours, you need to separate yourself from that attorney as quick as possible. It doesn't really matter kind of what stage in the game you're at. That's just a bad attorney. So if that's their tactic, if it's the opposing side who's doing that, as you know, it's the opposing attorney who's just racking up attorney's fees. Well, if it's being paid for by the opposing party, that's their problem. If it's being paid for by the trust, that is not just their problem, because if you're a beneficiary, those fees would have to be a part of the negotiation of the settlement. And you can say absolutely, because that happens where people will show up in mediation and they've got this, you know, $100,000, $200,000 attorney fee bill, and you have to look at it and say, was it reasonable? And if it's not, then that's going to be a real sticking point. You might be blowing up the settlement negotiation unless they're going to come back off of those attorney's fees and have to pay some for themselves. Or the other option is that those things have to be, you go and you try and get your accounting approved in court, and somebody's going to object, the beneficiary is going to object and say they spent too much on attorney's fees. And then a judge is going to make a decision as to what was reasonable in that sense. As for the them trying to use it as a tool to obtain an advantage in litigation to try and bleed you out, yes, that happens. And what can be done about it? You have to be as efficient as possible. But if they're doing everything that they're supposed to be doing and you just can't afford the fight anymore, that's absolutely a tactic that gets used, is saying this just isn't worth it. I can't afford my attorney anymore. And what can be done about that? I mean, find an attorney who takes it on contingency. Sometimes there are attorneys like that, but otherwise using your attorney in the best way possible so that you're not running up a fee that you can't afford. Like it's a tough thing. It's a really tough thing to say they have a war chest that's bigger than ours. What are we going to do? That's something you'd want to discuss with your attorney well beforehand, budgeting out what your fees, what you can afford. Great
Okay.
question.
Well, thank you, Dan. So we do have an additional question that just came in from Carly. She wanted to know, will a mediator actually advise parties whether their positions or evidence will hold up in court and what will not?
Well, I'd be happy to answer that question. So it varies from mediator to mediator, but my answer is I will be happy to give you my perspective based on my experience. That's part of the value that I provide as somebody who's been litigating in this area for almost 30 years. So yes, I will do that. Now, you have to keep in mind when I'm telling you that, that's not a decision. You're not bound by that. I am simply giving you the benefit of my own experience and my own analysis of the information you've shared with me. And of course, if you're represented by counsel, I would encourage you to defer to that person's analysis. And I'd want to hear that. If I have a different perspective, and I think it's constructive to share it as part of the process, then I will do that. But to answer your specific question, if a party asks me about their factual position or even their legal position, I will provide that, but it'll be my perspective. It won't be a decision.
Exactly. Agreed. Where there's happened coming from the litigator side of it. It happens all the time where I am disagreeing with the mediator on their analysis. That happens. And so the mediator will tell you what they think. Your attorney sure as heck better tell you what they think, because that's what you're paying them to do. But yes, those opinions on your facts and the law and how the law applies to those facts, you're going to get that in mediation. Most times the attorney and the mediator will likely agree on it, but there may be some issues where your attorney and the mediator will think differently, but saying that in court, were this to go to trial, I think the judge would decide this way. Mediator would say, I think we're going to decide that way. So that happens.
I will say this. It would be again what Dan just described in terms of the degree to which a lawyer and I disagree is really a function, I think, of the lawyer that you have. That is, I think it would be very rare for Dan and I to disagree on the applicable law or the process, because Dan's got a lot of experience in this area, as do I. Where we run into trouble is where we have either a lawyer who doesn't have a whole lot of experience trying to wing it in this particular area, or a mediator, and that's where you get into trouble in these cases.
All right. Thank you guys so much. I think we are just about out of time. I don't see any remaining questions. So thank you to those who did ask questions. We do have one more slide I wanted to show you here at the end before we go. On this last slide, you'll see the contact information for both of our speakers today, and each of them have a generous offer for those of you who have taken the time to come to this webinar today. I know at our office, we are happy to schedule you with a no-cost initial consultation with an attorney. Daniel Spector has also made a similar offer where you can get the first 2 hours of mediation time for free. These are really valuable offers, so I encourage you, if you're interested, to use this information and take advantage of those if you'd like, and continue the conversation. So before we go, I just want to thank you so much for joining us today. It's been a pleasure. Everybody stay safe, stay healthy, and let us know if we can help in any way.